So, terminology. There's a terminology to probate, and it's important that if you're going to do this, you understand the terminology involved, because you'll see it over and over again. So first of all, probate. What is probate? This is what this whole thing is all about. So probate is a legal process, and it's a process by which a person who doesn't own property gets the authority to deal with it. So if you think about it, the testator, the person who makes a will, has died. He owns a house. That house has to be sold. The executor can't sell the house right away because he's got no title to it. First thing everyone will want to know is, on the other side, is what's your authority for selling the property? And that authority is the grant of probate, or as I said, the grant of letters of administration. And there's a set procedure for doing it, which is also what this webinar is all about. What is a will? A will is a legally binding document. The unique feature of a will is that it only becomes legally binding when the person who made it has died. Before that, obviously, while he's or she's still alive, she can make as many wills as she likes. The other feature about a will is that it has to comply with the Wills Act 1837. That's right, an act which was made 180 years ago is still regarded as the last word in this area, and as far as I know, there are no plans to change it. And to make a valid will, you need 3 points covered. You need a document, a written document. There's one exception called privileged wills, which really only applies to servicemen on active service. Everyone else will need a written document. It needs to be clear in its intention for obvious reasons to avoid disputes. And the third one is it has to be signed and witnessed in accordance with the Act. So you have to have the testator who has to sign the will in front of 2 people who should also be present at the same time. If that is not followed, if you get, say, the testator signing the will, and while the witnesses are signing, he pops off and makes a cup of tea, which has happened in another room, that is not a will. And that is, the law is completely rigid in that respect. So what you have then is not a legally binding document, but a letter of wishes, which the family can choose to accept or ignore as they see fit. So that's a will. Testator, what I think I referred to just now, a testator is the person making the will. Testatrix, or testatrices, if you want to use the plural, is the feminine version of that word. It's kind of old-fashioned to use that now. You really just see people referred to as testators, whether male or female. Intestacy. Intestacy, again, as I've referred to, is the situation where there is no will. And in that situation, the law has to make a series of assumptions because there is no set of instructions from the testator. And those assumptions are basically a list and use of the people who will benefit and the people who can apply for intestacy, apply for the grant of letters of administration. And that list is rigid. It's fixed and basically go from one category to another, working your way down the list until you find someone who qualifies. To the top of the list is spouse, and note that does not include an unmarried person. Unmarried couples cannot benefit from intestacy, so if a person dies in an unmarried relationship, his estate will not go to his partner, no matter how many years they've been together, it will go to his family. In other words, the next person down the list. Grant of letters of probate, so grant of probate versus grant of letters of administration, I've covered that really. Grant of probate is where there's a will. Grant of letters of administration is where there's no will. Executors or administrators, again, that's a question of terminology. Executors are the people who are appointed where there is a will to deal with the administration of the estate. The administrators fulfill the exact same function, but they come in where there is no will. Trusts and trustees, well, there are whole libraries full of books trying to establish the difference, or trying to explain what a trust is. Trusts essentially is where there's a division in the title. So you get a legal title, people who actually own the property. They are the trustees, and they'll hold the property on behalf of another bunch of people called the beneficiaries. The beneficiaries can include the trustees, but they are essentially two completely distinctive groups. A good example of how this works is pension funds. A pension fund is owned, technically speaking, by the trustees of the pension fund, usually the company. But they will hold it under the terms of the trust on behalf of the beneficiaries, the pension holders, in other words, you and me. Trustees are the people who own the legal title, and there is an awful lot of powers and duties of trustees, which, as I said, is quite a complicated subject. There are also tax implications, which again, not for this particular webinar. So we'll move on.